Good evening and welcome to this week's edition of What's Going On. I'm your host, Pastor Akim Bandele. I welcome everybody. Well, we are in March and we thank the Lord for this month. Amen. I know many of you uh, you've had challenges from the beginning of the year, from January and February. But now we're in March, so you need to expect God to move on your behalf. But tonight, I want to welcome you. Help us. I thank you, first of all of you that are subscribing to our channel. Everybody that has subscribed to our channel, we thank you, thank you, thank you. Without you, it won't matter what we are doing. So we thank you for being part of our family. And also, I thank all of you that press your notification bell so that every time we come live like this, you are notified. So welcome. Tell us where you are from, where you are watching from. We want you to be involved tonight and comment. Before I start our program, this is the first Thursday of March. So I want to wish everyone celebrating birthday in March, happy birthday to you. Happy birthday to you. Happy birthday, happy birthday, happy birthday to you. Happy birthday to everybody celebrating in the month of March. May the Lord bless you. May the Lord give you increase. May the Lord give you the desires of your heart. I want to give a shout out to Raymond. Raymond is celebrating his birthday on March 18th. And then Minister Ford also celebrating her birthday, amen, in March. So I have those two birthdays in March. If you're celebrating your birthday in March, why don't you post it? Let me see who are out there that are celebrating in March. Just let us know where you are joining us from and what day is your birthday. Amen. We want you to come in tonight so that we know where you are from. And I'm actually trying to see all of you that have joined us right now to see who are coming in about their birthday. Amen. So, but tonight, while you are getting ready, we will. I'm still trying to get to my. Okay, you'll give me a minute. I'm trying to find all of you all. I can't find you yet. So I'm going to try to find you. But why, if you can hear me, say something. Let me know you can hear me. Let me know you can hear me. I'm going to see what's going on. So, okay, here we are. Let me see who are on. Tell us who you are. I'm going to say hello to everybody just to see which one of you is already joining us. Hello, everyone. Okay, I see DJ Hopes. Okay, DJ, I see you. Thank you for joining us tonight. So now I can see the comments of everybody that has joined us. Well, who is having birthday tonight or this month? If you're having birthday this month, I've got a drink. I've got a drink. So go get you a drink and we're going to celebrate together. All right? Go get you a drink. Go get you a piece of cake or get you some food, whatever it is you're going to celebrate with. Happy birthday to you. Amen. So I drink to your birthday, okay? All right. All righty. Okay, birthday. Well, we are going to be talking about family matters tonight. Family matters. I've had to encounter a lot of questions from people that are dealing with family legal matters. Family legal matters. Whether you are married, divorced, remarried, have children, have properties. We're going to talk about some of the things that you have been asking tonight. We got several questions And tonight, I'm not a lawyer, I'm not an attorney, but I have a great attorney with us tonight, Attorney Oshole Hopes. Is right here in Houston, Texas. I want to welcome Attorney Hopes to our program tonight. Good evening, Attorney Hopes. How you doing?
Fine, Pastor. Good evening. Thanks for having me.
All right, all right. Well, good evening, good evening. We're going to be asking you some questions tonight. Before we ask questions, I want you to tell us uh, uh, what kind of laws do you practice? And then we are dealing with family matters tonight. So Attorney Hopes, I have several questions that I'm going to be asking you as it relates to family legal matters. So introduce yourself.
My name is Oshole Hopes. I'm an attorney licensed in the state of Texas and New York. I specialize in family law, DWI, immigration, and personal injury.
Okay, hold on. Slow down. Number one, family law.
Yeah,
Okay, what's the
family law,
second one?
DWI.
DWI, all of your drunks out there. So if you drive while intoxicated, Attorney Hopes can
Personal,
get you out of the jam. Okay, what was the third one?
personal injury.
Personal injury. Some
Yeah.
drunk people hit your car, or maybe you fell in somebody's house, or somebody's roof fall on your head, whatever it is. So personal injury. What else?
Immigration.
Immigration law, that is for people that are in America from another country. Maybe
Yeah.
you've traveled into America, and whether you come on visiting visa or you come with a student visa or F1, F2, all kind of visas that you can come with, and maybe you want to become a resident or you're already a resident with a green card, you want to be a citizen. So Attorney Oshole Hopes can help you with all that. All right. Thank you very much. Well, we're going to talk about family matters only tonight. Okay. And I have some questions I'm going to ask you.
Okay.
Let's say two people are involved in a romantic relationship and it ends, they part ways, right?
Okay. Okay.
Now, but when they are in this romantic relationship in Texas, they end up living together, not
Okay.
married, but living together. If they go their separate ways, will they have to file for a divorce? How long have they have to be living together? I know there's a common law marriage in Texas. Explain all that to us, the way it works.
Okay, actually, it depends. If the court actually finds that a common law marriage exists between the parties, then they will have to get a formal divorce to end their relationship.
But
So the rest,
hold on, how would the court find out
okay,
what makes it a common law marriage?
okay. So there are several factors. The first one is that both parties must agree to be married, and then the second factor is the fact that they must have lived together. After they have agreed to be married. However, Texas law does not specify the duration of time that both parties must have lived together. It could be 1 day, 2 days, 3 days, 4 days, to satisfy that particular element. And then the last element is that they must represent themselves out to the public or to third parties as being married. So, for example, let's say they commingle their assets together, they file taxes together, Patrick calls Pat my wife, Pat calls Patrick my husband, or let's say they wear wedding rings. So in such a situation, the courts would hold that, yeah, there is a valid common law marriage.
Okay, but hold on. We didn't talk about marriage. We met in a club and we did it for a month, and we decided, you know what, let's just let me move in with you. So the man moves in with a woman, or the woman moves in with the man, but they didn't talk about marriage. They are just living together.
Okay.
And they file their tax returns separate.
Okay.
They don't have joint accounts.
Okay.
But they are living in the same house. They go out together. People see them outside together. They go to church together, but they're not married. They go to dinner together. They are living in the same house. Is that considered common law marriage in Texas?
Okay, so basically, these three factors must exist together, like they go together. So the fact that a guy stays with a girl or a girl stays with a guy, it's not enough, for the court to find that there is a common law marriage. So the three factors must actually exist.
Okay, I see. Because
Yeah.
I've heard people that say, "Well, I lived with this guy for 12 years, but we're not married."
Yeah, okay. Actually, some people feel, I've had a client who felt she wasn't married to, her partner, but technically, when I actually weighed the case, I discovered that the court would likely find that there is a common law marriage because,
Right.
yeah. So basically, if you commingle assets together, and it becomes more difficult if they have children. So let's say they have children together. Most times, the court would want to legitimize the child, or the children, and be like, okay, yes, there is a common law marriage in this situation. So let's say, for example, they buy properties together, they live together. Whenever they go out for events, and they'll be like, okay, this is my wife. Oh, this is my husband. They might not mean it, they might say it out of or in a
But
joking.
they don't. Well, these people that live together these days, they don't ever say that. They say, "This is my friend," or "This is my partner," or "This is my
Okay,
girlfriend," "This is my boyfriend." We live
okay,
together.
okay. So even
We shack up. So, I mean,
okay,
this is real. They don't call each other husband and wife
okay,
outside.
okay. So even if they don't call each other husbands and wife, but technically they do the things husbands and wife do, like spouses do. So, for example, let's say I go to the bank, and I open a joint account with
No,
my
no,
partner.
no, 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 no. Okay. It doesn't really happen like that in real life. These people meet each other in the club. They, after dating for so many weeks, they decide, well, let's live together. So they start
Mhm.
living together as boyfriend and girlfriend. They don't have joint accounts. They didn't buy no property together. They
Okay.
don't, they just living together in the same house. That's it.
Okay, then in such a situation, the court would likely not find that there is a common law marriage because those three elements do not exist.
So
So
you're
even if you
telling
have,
me if a woman lives with a man for 10 years, they never got married, they don't have any children, they
they don't
don't have
represent,
bank accounts together,
yeah, they don't
is that
represent
not common
themselves.
law marriage in Texas?
No, if they don't represent themselves out to third parties that, they are married, despite the fact that they are staying together, that is not enough element to satisfy the requirement of a common law marriage.
Okay, well, thank you for clarifying that, because I've had cases where people say, well, we lived together for 2 years. He wants to leave me. No, he got to divorce me legally because we live together in the same house for two
Yes,
years.
yes, yes. Most times that is what happens. In the situation whereby one of the partners states that, okay, I'm done with the relationship, I want to get married to someone else, and then the other partner start contesting it. So those are in those instances, that is when the court will have to find if there was a valid common law marriage or not. So the fact that you stayed with a person, if the other elements are not present, the court would hold that there is no common law marriage.
Well, maybe that's why you need to stop shacking up with people. If you love them enough, marry them legally. Single lady, tell them to put a ring on it. Okay? Uh, uh, Antonio Shole, thank you very much for clarifying that about the common law marriage. We've
Okay.
got Clay's birthday, March the 24th. Happy birthday, Clay. Well, I drink to your birthday also, Clay. Happy birthday. Mm. Make sure your mom and dad get you some cake, okay? Get you some cake. Happy birthday. Happy birthday to you. Well, let's go to my next question that I have tonight.
Okay.
Husband and wife, they're married, and they have children.
Okay.
Both of them have jobs, but they divorced and they've gone their separate ways. In the event of the divorce in Texas, how do courts decide which of the parents will be the primary custodial parent? How does the court determine who takes the custody of the child?
Okay, so basically in the state of Texas, the standard applied by the courts to determine which of the parents will be the primary custodial parents is what is in the best interest of the child. So in actually making a determination as to what is in the best interest of the child, the court would consider several factors. So basically, which of the parents have been actively involved in the child's life. And if the child is up to 12 years old, the court would actually consider the child's preference. However, the court is not bound by the wishes of the child. So let's say, for example, the judge asks the child, between mom and dad, who do you want to reside with? And the child says, dad. If the court finds that it is not in the best interest of the child to reside with dad, the court will not honor the child's wishes. I don't know if you understand what I mean.
Yeah, I understand.
And yeah, so basically the court will also consider where the parent intends to reside, after the divorce. Like, would the neighborhood be safe for the child? Also, which of the parents have been convicted of a crime, let's say domestic violence, family violence, sexual assaults, and stuff like that. Basically, what is in the best interest of the child.
But it looks like every time I've seen it, they always give the children to the mothers. Okay. Even when some mothers are actually unfit. I've seen mothers that don't have a stable job. They don't have a stable apartment. They're living with this one with a child that's 5 years old. And it seems like court favors the mothers more than the fathers. Am I right by saying that or no?
I would say no. I tend to disagree. And the reason for me saying that is the fact that it depends on what your attorney can prove, to the courts. So basically, most clients are not willing to work with their attorneys, right? It is advisable that when you go to an attorney to talk about a divorce case and if there are children involved, it's certain like it's advisable you disclose, certain facts to that attorney to enable them help you, because like I stated, there are several factors the court will consider. So imagine if, let's say, the attorney representing mom goes to the court and states that, or proves to the judge that the child or mom has been the primary caretaker of the child, mom has been more involved in the child's life than dad, and then let's say the only factor dad can establish to the court is the fact that, okay, I earn more than mom. In such a situation, the court would likely make mom the primary custodial parent. I don't know if you get what I mean. So
no, I don't. Let me ask you this way.
Okay.
What I've seen is, I'm gonna say it again. I know you disagree with me.
Okay.
99% of the time, the court gives these children to the mother. And I have instances. The mother is actually unfit. She leaves the children at home by themselves. She is not really a good mother. Now, she has a job, and the father has a job.
Okay.
He has a bigger house. He has more finances, and the court still gave the children to the mother. And to even make it worse, this mother then turns around and drop off the children at the father's house for them to stay there, and she's collecting child support. So the father has to go back to court. But the court did not find the mother unfit. She told the court, well, I'm just letting them spend time with dad, even though she's not able to take care of those children. How does you say, well, I mean, what factors? Does it mean that whoever has a better attorney wins?
Okay, Pastor, I'm going to explain this again, right? So basically, there are several factors the court would consider, and I'm going to be listing some of these factors. Now, the more factors you can prove in your favor, the better you stand a chance to being the primary custodial parent. You see what I'm saying? So even though dad has a bigger house, right? If mom has a house, even though it's not as big as dad's house, but provided it's in a safe neighborhood, the court is not going to look at that factor, that the fact that dad has a bigger house and mom has a smaller house. That is not compelling enough reason for the court to state that, okay, it is not in the best interest for the child to be with mom. Now, it is where
I know. See, this is not clear cut. I'm talking about real stuff here that I'm familiar with, people that I know. Okay, mom has a good job, dad has a good job.
Good.
Mom lives in a good neighborhood, dad lives in a good neighborhood.
Yeah.
Mom is involved in the child's life, dad is involved in the child's life.
Okay.
The child is 7 years old. Mom lives in a school district that's nice. Dad lives in a school district that's nice. Who does the court give the child to?
Like I said, it depends, right, Pastor? If mom's attorney establishes to the court that yes, these factors weigh in dad's favor, these factors also weigh in mom's favor, but dad has been violent towards mom in the marriage. Dad
No,
has been
it's not violent.
Okay, it is not violent. Okay,
right.
Well, in such a situation, you get to pull up articles that establish that when the child is young, it is better the child stays with mom.
That's what I'm getting at. Everything I've seen, the court always rule in the favor of the mothers. That's what I've seen.
No, Pastor, that's not true. Sometimes, like in recent times, the courts also rules in favor of the dad. Once they realize that, or once you're able to prove or establish that it's not in the best interest of the child to reside with mom.
Okay, all right. Well, we're gonna leave that alone because the case I'm talking about is a real case that just happened 2 months ago. Okay, let's move on. Let's move on. And everybody that's watching us, if you have questions, feel free to ask your questions, and we will try to answer your questions tonight. Let me go to my next question. Can you tell us about the types of child custody in Texas and the implications of each?
Okay, so basically in the state of Texas, we have the joint managing conservatorship, we have the sole managing conservatorship, and then we have the possessory conservator. In most cases, the courts
explain each one of them to us.
Okay, yeah, I will. So in most cases, the court actually prefers awarding joint managing conservatorship because both parents get to be involved in the children's life, and both parents actually, have the right to make decisions over the children's life. Now, in a situation whereby the court awards joint managing conservatorship, let's assume both parties are going through a divorce. If you look at the final divorce decree, you get to realize that there are certain rights, duties, and responsibilities of each party. Now, once the court awards joint managing conservatorship, one of the parents will be designated as the primary joint managing conservator. The other parent will be designated as the non-primary joint managing conservator. However, with respect to taking key decisions over the children's life, mom cannot make those decisions without consulting with dad and seeking dad's approval.
Okay.
See what I'm saying?
Yes.
Yeah. So key decisions like, with respect to consenting to the child going through, would I say, an invasive medical procedure, with respect to consenting to the child going through psychological care, the child enlisting in the military before they turn 18 years old, the child getting married before he or she turns 18 years old.
What about traveling out of state?
Yeah. So basically, yeah, that's part of that. I wouldn't say that is a key decision, but it all depends to the court. It all depends on the court, actually. But most decisions, once the court designates both parents as joint managing conservators of the children, they will be able to take most decisions, over the children's life. Now, in a situation where the court is of the opinion that it is not in the best interest of the child to make both parents joint managing conservators, what will happen in such a situation is that the court would make one of the parents sole managing conservator and then the other parents the possessory conservator. Now, if the court does that, what it means is that whoever is made the possessory conservator wouldn't have the right to make decisions or make key decisions over the children's life. See what I'm saying?
Yes.
It's not like the primary conservator wouldn't have certain rights. Obviously, he will have certain rights, but key decisions like, is the child going to be enlisting in the military before they turn 18 years? Is the child getting married before they turn 18 years? Consenting to invasive medical procedure, psychological care, acting as a child's agent, for the child's estate, representing the child in legal proceedings. Those rights are exclusively reserved for the parent who is the sole managing conservator. But if the court had awarded joint managing conservatorship, both parents would have the right to take decisions for the children with respect to those areas.
Okay.
Yeah.
All right. I know you say you're going to explain the three. You gave us one. What was the second one?
Okay, so the first one is the joint managing conservatorship, where
What's the second?
The second, the sole managing conservatorship, the third is the possessory conservator. So if the court awards sole managing conservatorship or makes an order and states that, okay, we're awarding sole managing conservatorship, mom is the sole managing conservator, then dad will be the possessory conservator.
Okay, okay. What does that mean? That means the child lives with mom?
Okay, so the child gets to reside with whoever is designated. So if the court awards joint managing conservatorship and makes mom the primary joint managing conservator,
so the child stays with mom.
Stays with mom. Now, if the court awards sole managing conservatorship and makes mom the sole managing conservator and dad, the possessory conservator, it means the child will stay with mom. Now, it doesn't mean dad does not have visitation rights, or it doesn't mean.
When can the child stay with dad?
Okay, so basically, if you're going through a divorce, you get what we call the standard possession order.
No, they've already divorced. Attorney Schiller, they already divorced.
Yes, that's what I'm saying. So
when can the man be where the children live with him? What would the court have to do with this? I know everything is leaning towards the mother. When the court say, okay, we find the father being the better parent for this child, does the court give that man sole conservatorship?
Yes. And okay, I think I'll start using dad as the example. So if the court finds, or if the court awards joint managing conservatorship and the court makes dad the primary joint managing conservator, child would stay with dad.
Okay. All right. Now, what about when one is have a sole conservatorship and they have a joint custody where the child can visit the other parent on weekends or they spend holidays, they spell it all out.
Yeah.
Where, okay, you pick up the child on Friday, Saturday, Sunday, you bring the child back on Sunday night because
those are all...
the child got to go to school Monday to Friday, living with mom or living with dad, living with either parent. Now, what happens if a parent disobeys the child custody orders given by the court?
Okay, so in such a situation, you can seek to enforce the child custody orders. Most times, I advise clients to, have some sort of proof because it's your word against the other parent's word, right? So basically, if you text dad and be like, I want to pick up the child, or I want to pick up Patsy, and dad says, no, you can't pick up Patsy, or dad refuses to hand over Patsy to you, it's good to document these things because they serve as evidences that they have disobeyed the court's order. So in such a situation, the courts you'll be in contempt of the courts, basically.
Okay, so the other party, whether mom or dad, can take the party that's disobeying the court order, the child custody order. The parent that's disobeying that can be brought back to court.
Yeah, but you can.
The parent has to document how that custodial parent is disobeying the child custody orders.
Yes, and
let's say they pick the child up and supposed to bring the child back to the dad or to the mom at 4 o'clock.
Yeah,
at the particular place that they decide they're going to meet, and the custodial parent or the one that's granted the right to see the child does not bring the child back until 7 p.m. and the dad just stays on the parking lot of wherever they decide to meet. So the dad can, the parent can document that so many times and then go back to court to say, okay, every time I get the child, every time he gets the child, he brings the child back so late, 2-3 hours late. Or every time she gets the child. Could that be reasons why you drag the other party back to court? Yeah,
so basically, in most instances, it's advisable that before you seek to enforce the court's order, it's a repetitive action. So basically, not just once, twice, it's something that is constant. And I always advise clients that in situations whereby the parents that has been designated as a primary, or let's say one of the parents actually has refused to release the child, right? Because if you look at a divorce decree or child custody order, you would realize that the court has granted rights to probably the sheriff or a constable to actually enforce the court's other. So in such a situation, if you can reach out to like the local sheriff that, okay, I have a court order, I want to pick my son and his mom is preventing me from doing that, because those things are also documented. Yeah. So that would also serve us. Yeah.
All right. If you have any questions, you are watching us, maybe you find the child custody battle and you want some clarity, you can put the question on our comment, and I will send the question to Attorney Hopes. If you're joining us tonight, welcome to What's Going On. In this week edition, we are talking about family matters and family laws. So thank you for joining us. I want to give a shout out to Alice Hinkson. She made a comment that her lawyer may be better than his lawyer. And because we see a good dad, you have to be in that house to know that dad or mother. So basically, Alice is saying whoever has the better attorney sometimes wins. Is that correct?
I somewhat, but it also boils down to the clients, because clients will have to help their attorneys to establish their case. I mean, attorneys don't live with their clients, so
Yeah, but okay, if you have a real good attorney, high paid, top-notch attorney, and the other parent don't really just have a court appointed attorney or $3.99 attorney, do you really think the one that does not have a good representation can win a custody case? Do you think?
Yes. Yeah. People actually represent themselves in court without even attorneys, and if you can, it all boils down to what you can establish or what you can present before the court.
Before the court, okay. So it
Exactly.
all depends on paperwork and things and things that you can present to the court to justify your case.
Yeah.
All right. Okay. Well, I've got a comment online. Beck says, what are the determining factors for who gets primary custody? What are the determining factors? I think you may have mentioned it earlier.
Yeah.
Maybe this viewer is coming in late. What are the determining factors? You said there. Can you just summarize the factors one more time before we go on to our next topic?
Sure. So it is what is in the best interest of the child, and in making that determination, the court will consider several factors. Who has been actively involved in the children's life. So who takes the child to school? Who goes to pick up the child from school? Who takes the child for medical checkup? Who takes the child for their games? Who has been actively involved in the child's life? Has any of the parents been convicted of, let's say, family violence, sexual abuse? And if the child is, like I said, if the child is up to 12 years old, the court will also consider the child's preference. It doesn't mean the court must abide by the child's preference.
Okay.
Yeah, exactly. But the court will consider the child's preference. Where would the parents reside? Is the neighborhood safe? Or is the child actually... So let's say, for example, during the marriage, both parents resided in, let's say 8055, like an address or whatever. And when they splitted, dad moved to a different city entirely. But the child or the children have been going to a school located in that neighborhood where, both parents had resided during the marriage. And mom still decided to reside in that same neighborhood. The court would be like, okay, yes, you guys are getting divorced. I don't want the divorce to affect the children. They're already used to this school. We want them to maintain this school because they made friends, obviously. So it's in the best interest of the child that the child actually resides with mom.
What about this school? If the school is a horrible school, drugs and everything, and the father say that's the reason I divorced her because she's a crackhead too, and I can prove it. I've got stuff right here to prove it. And the child who is 11 or 10 say, yeah, mama be smoking dope, and mama shoot up with needles, and some uncles come to the house. And I mean, if the court hear that from the child, you think they will still give the child to the mother?
They wouldn't want to give the child to the mother. However, if the mom can prove that, yes, I'm this way, or I have done these things, but that is worse. Dad is a convicted sexual offender, or dad is a sexual offender, dad is a criminal, dad is a drug addict.
Okay, so it boils down to, again, the attorney that you have and what you can prove.
Yeah.
I rest my case. It's hard to be poor. It's hell to be poor. Because if you're poor and you can't, I think it all still depends on when you have a really good attorney that can dig up stuff. And I mean, I'm telling you, I've known good dads that the mom is a horrible mom, but because she's got a very good attorney, she kept that man in court for months and months and years and years. And even when the child kept saying, no, I want to stay with dad. Dad, mom is never here. Mom works late and we are home by ourselves and all this stuff. The court still let those children stay with mom because she has a good attorney. And the attorney always filing motions and that motion and that motion and this motion. Again, I think Alice Hinkson said it, whoever has the best attorney wins. I'm going to leave it like that. I'm going to just leave it right there. Let me see if there's any questions. Okay, let's get away from that right now. Let's go to before even people get married. Somebody has a question. They said, okay, I'm getting married, and but because I'm wealthy, and this person I want to be married to, they know, okay, I'm worth $10 million, and I'm marrying somebody that's worth $50,000. So the sister that's worth $5 million or the brother that's worth $5 million decides to do a prenuptial agreement before the marriage.
Okay.
Right? After they get married, a year, 2 years, 3 years, and let's say they separate, they want to divorce, does the prenuptial agreement stands a ground to where the party that signed the prenuptial cannot take the asset of the other party that's worth $5, $10, $20 million?
So when parties are married, what governs then is a postnup, no longer a prenup, because a prenup is before you get married, So let's say a postnup. So let's assume parties get married and they draft a postnup after the marriage. Do you understand what I mean?
I've never heard of a postnuptial agreement. I've always heard about prenuptial agreement.
Okay.
I've never heard of a post. Why would somebody do a post?
So it's just the name, post is after the marriage, before the marriage.
Let's deal with the one before the marriage, because that's the one that I commonly hear about.
Okay, so let's assume I'm talking about a postnup, but let's call it a prenup, right? The court would actually enforce it if it reflects a just and right, equitable division of, the parties' properties. And however, there are certain factors that can invalidate a prenup. So if one party can establish that, okay, this other party did not disclose their assets to me as at the time I executed this prenup, then the court would invalidate it. Yeah, that invalidates it because you are bound or you have an obligation to disclose all your assets before that agreement is executed. Or let's say, for example, the agreement was not signed, it's invalidated. Or let's say the terms of the agreement are so in favor of one party. The court will be like, no, this is really unfair. We're not going to honor this agreement. We're going to have to divide the properties between the parties, in a just and fair manner. Or let's say, for example, one other party induced the other party. Let's say you have to get into that agreement voluntarily out of your own free will. So if you were induced or if you were coerced and you can prove that, then the court would invalidate the agreement. Or let's say, for example, the other party made a statement to induce you to execute the agreement. That's called fraud. So if you can establish...
like I'm not going to marry you if you don't sign a prenuptial agreement. Is that induction?
It depends on how you actually... it depends on how you actually, establishes it. So, yeah, I would say technically...
I have a situation where there's a prenuptial agreement And
Okay.
they got married, and then they got a divorce. And the wife went after the husband that prenuptial agreement should not stand because she was not in her right mind when she signed it.
Yes.
She said she was
Intoxicated?
not intoxicated, but she was not in the right frame of mind when she signed it. That she didn't know what she was signing and all of that. And but the
Okay.
problem with that is the court almost ruled in her favor until the husband said, "Hey, Your Honor, hold up. Yeah, she was pregnant, she was sick and all that. She signed it. And when she gave it to me, I asked her to go find her own attorney. Let her attorney read it. So
Yeah.
now she went and found her own attorney, and her attorney signed it. So the judge said, since
Yes.
you have an attorney, you signed it, you said you were sick, and you didn't understand what you were signing. But you got your own attorney, and your attorney read it, and you all talk, and you signed it. That prenuptial actually stood ground in court.
Yes. So in most cases, it's advisable for both parties to get an attorney,
That's right.
for that agreement. Yeah, that helps a lot.
Yeah, once your attorney signs it, and his attorney signs it, it don't matter if you say you were crazy or you are nuts or you ate spaghetti and you were throwing up when it won't matter. You have an attorney that's read the prenuptial and you signed it and your attorney signed it.
And the court also presumes that your attorney must have explained the terms of the agreements to you, because the attorneys are under the duty to do that. Yeah.
Okay, what about if she said, well, he didn't explain it to me?
At that, I don't see how that's going to stand.
That's what I'm saying. All right, let's move on. Somebody asked a question about child support. How does the court determine the amount of child support payment in Texas?
So basically,
and who pays the child support?
So basically, the court considers the net income of the obligor. So the person who is responsible for paying child support is the non-primary, because that's the parent who the child is not primarily residing with. Do you understand what? So let's assume the child primarily resides with dad. It means mom will be responsible for paying child support. Okay. Now, mom, so I'm going to be calling mom obligor and dad obligee. So with respect to the amount of child support the court would award, it all boils down to the net income of the obligor, which is mom. And also the needs of the child. So basically, what are the needs of the child? Like schooling, clothes, feeding, housing, several factors. So those are the factors.
Okay, let's say the parent that's paying child support to the other parent, let's say that parent is a millionaire.
Okay.
In the state of Texas. How much is there a cap for child support in Texas? I believe there is.
Yes, so actually there is. If you look at the child support guidelines, there is, I think, one child, 20% of the obligor's net income, 2, 25, 3, 30, 4. But
okay,
again,
hold up. 25% of the earnings?
No. So if you look at the child support guidelines, I believe
one child.
20% of the obligor's net income. 20%
of the net income.
Yes, but the court is not bound to abide by the child support guidelines. So sometimes they might deviate from it, but in most cases they actually abide by it.
Okay, so 20%. So you've got somebody that's making $100,000 a month.
But no, Pastor, that's not how it works. So
well, hold up. You said 20% of the earning of the party that's paying child support.
No.
So this person earns $50,000 a month.
Okay. So 20% of his net income, of course, you consider his taxes, right? He's going to be paying taxes. So his taxes are not part of his net income, union dues. There are certain things the courts or certain expenses the courts would deduct from whatever he earns, right? And there are certain things the court would not deduct. So when the court ascertains his net income, so things like unemployment benefits, bonuses, wages, once the court has determined that, okay, this is the net income of the obligor, so it is going to be 20%.
Okay, I'm saying it again. I'm asking again. The net income of the obligor.
Okay.
The net income, not gross, the net income is $50,000.
Okay, 20%.
That's not what I've been told. Maybe I'm wrong. I was told that in the state of Texas, it doesn't matter if your net income is $1 million. The maximum in Texas is $2,500 for that child.
Oh, no. No. If you look at the child,
you are telling me the obligor can pay $6,000 in child support?
Actually, Pastor, like I stated, right, the court will also consider. Remember, I told you that the court is not bound to follow the basic child support guidelines, right? It's just a guideline. Yeah. The court would also, consider the needs of the child or the children.
Okay.
But if you look at the child support guidelines, it states one child, 20%, two, you see what I'm saying? But the court is not bound by the guidelines.
Okay. I'm looking at something right here because I know this has been the case.
Okay.
Yes, Texas divorce law state the maximum child support amount for one child is $1,840. This is because state law dictates a maximum amount of net monthly income that can be used to calculate the child support, which is $9,200. Well, I tell you what, because there's an instance that I know that this person was paying almost $3,500 in child support, and then the woman took him to court and wanted more because she feels like he has more assets and all of this, he has more money. And the court demanded that he brings all of his stuff, and he told the court, ma'am, I'm not doing nothing. You can charge me the maximum in the state of Texas. And the woman was getting $3,500 a month. The court actually reduced it to $2,500.
I don't know of that case, but again, if you look at the child support guidelines, I presume you can browse that at child support guidelines, you'd see one child, two children. But like I said, the court is not bound by the guidelines.
Okay.
Yeah.
So the court can just do whatever they want.
Yeah. So, but no, not like they can do whatever they want. They'll consider the needs of the child or the children, and they'll also consider if the obligor has other children. Those factors will come into play too. So let's say, for example, the obligor has other children with another party, right?
Yeah, they're going to take all that into consideration. Yeah.
Yes.
Okay, I've got a question coming from online. Why do the court allow someone to sell your house when getting a divorce?
Okay. Like, can you rephrase that question? Someone to sell your house when getting a divorce.
Okay, why do the court allow one of the party to sell their house when they are getting a divorce?
So basically, right, in the state of Texas, Texas is the community property state. So let's assume the house was purchased before the marriage. Okay. So let's assume before Patrick got married to Janet, he bought a house, in his name, he got a mortgage. That house is considered a separate property because the house was acquired by Patrick before the marriage. Now, in the event of
Antonio Shole, I disagree with that. Let me tell you why.
I'm not done. Okay.
Okay, you're not done. Okay, go ahead. Because I have a situation where that happened.
I'm not done.
Okay, go ahead. Okay. Yeah. So the house belongs to the one that purchased the house before the marriage.
Yes. However, right? Let's assume after they got married, community property was now used to probably improve the house, renovate the house, because after the marriage, incomes generated by the parties after the marriage is regarded as community property. Okay. See what I'm saying? So let's say after the marriage, my pay, my wages, anything I earn from my job will be regarded as community property. So let's assume I use my own wages after the marriage to renovate the house I bought before the marriage. In such a situation, the other spouse will be claiming reimbursement. Oh, yes, he bought the house before we got married, but community property was also used to improve separate property, and I'm going to ask what he needs to reimburse that. You see what I'm saying? He has to reimburse that to the community estate. And then another instance where a party, even if, let's say, the house was purchased after the marriage, right? Sometimes parties can come into an agreement, and say, okay, now let's leave the court out of this. Let's come into an agreement. Let's either mediate, or the attorneys can come together and be like, okay, both parties have agreed that Patrick should keep the house. You see what I'm saying? Okay. Then Pat or Janet should keep the cars. So the division of the property now is based on both parties. Now, in that instance, if the court approves the agreement, Patrick can sell the house, even though the house was purchased after.
So both parties have to agree in the divorce decree. The person that's asking the question, can you re-ask your question properly? Because I don't think Attorney Shirley understands your question very well.
If you don't agree, if you don't agree.
Attorney Shirley, hold on. I'm going to have the person, the comment. There's a person that's commenting and asking this question online. I want them to re-ask the question. Go ahead. The person that asked the question, why do the court allow someone to sell your house when getting a divorce? Can you re-ask the question and give us a better? We don't understand what you are asking, so we don't want to muddy up the water right now. We really don't understand what your question is. So re-ask your question, and I will read it to Attorney Oshole. While I'm waiting on that question, I believe we have one more. Okay, somebody asked a question. Is child support payment tax deductible?
Child support payment is not tax deductible. So basically, you can, it's not tax deductible. But the primary custodial parent gets to claim the children for taxes. However, the obligor cannot claim tax deduction based on the fact that he pays child support. But the obligee who receives child support also gets to claim the children for taxes. You see what I'm saying?
No, that's not fair. Because, okay, now, the child is staying with mom, or let's say the child is staying with dad, and mom is paying child support every month. At the end of the year, because mom is paying the child support, mom want to claim the child on her taxes.
Oh, no.
But dad said no, because the child stays with me. So I think the tax law says, if I remember correctly, the tax law determines how long you stay. The custodial parent usually have the right to use the child as for tax return. Now, because they feel like the child stays with this custodial parent for 9 months out of the year, and you only pick up the child 2 days out of the week. So I think that is kind of clear cut. But sometimes the parents can say, okay, you claim him this year, I claim him next year. If they agree, I get that would be okay.
That is okay. So most of these issues, right, can be resolved by parties either through mediation or probably through, lawyers do what they call a band-aid agreement or an agreement. So basically, they can mediate and then they'll come into an agreement. Now, if they're able to do that, fine. If the court approves whatever they've agreed upon, fine. If they are able to resolve this amicably, then the court would come in and give an order. You see what I'm saying?
Okay.
Yeah.
All right. Well, I think the question that was asked, I don't see it. I don't see the question re-asked again. But I think the person that asked these questions is asking, when there is a divorce, why do they have to sell the house? Why can someone that want to stay in that house not sell it? And I think I know the answer. If somebody want to keep the house and they are willing to give half, they have enough money to pay the other party half of the property, I think they can stay in the house. Is that correct?
Yes. Yes. So if it is community,
there's community property, they are married, they divorced, so the house has to be split half.
No. So if it is community property, right? And of course, the court would divide. Let's assume they are not able to reach an agreement over this issue, and the court is left for the court to now decide how the community property will be divided. Most times, or what would I say, the court is not bound to split the properties or the community property between the parties equally. They'll consider several factors.
What are the factors considered?
So, for example, they'll consider the contributions of each party, to the acquisition of that property, whether each party have committed waste, the age of the parties, the health conditions of the parties, the separate properties of the parties, the debt and liabilities of each parties. If one of the parties was at fault, if one of the parties led to the breakdown of the marriage, what would the other party have derived from the continuation of the marriage? These are factors the court would actually consider in making a division of the community property. Now, it doesn't mean
it still boils down to whoever has a good attorney. Yeah, everything is boiling down to whoever has a good attorney wins. I've got a question online.
Okay.
Can my husband sell our house without permission if we get a divorce?
Is it separate? Actually, when a divorce proceeding has been instituted, at that point, your attorneys will advise you don't even sell anything, right? Because the court has to ascertain whether it's community property or separate property. However, if it is separate property, it is yours. You can sell it. But if it is community property, it means the both of you technically own it. So you cannot sell it without the other party.
That's right. So the answer is no, he cannot sell the house without your permission, because when it goes to closing and they know it's a community property, the title company will want the other party to agree for that house being sold. And the way I've seen it happen, again, this is not just theory, this is the real life stuff that I've seen happen, where at closing, they actually gave the wife a check and they gave the husband a check. There's been a situation where they are not even divorced. They were just selling an investment property. And the other party said, when you cut the check, give me mine, give him his. And that's what they did. The title company wrote 2 checks, one to the husband, one to the wife, even though they are not divorced. They're still living together. So there's so many variations that can happen to where it's always good to have a legal counsel. And I want to say again, whoever has a good attorney wins. I'm telling you right now, that's what I know. Whoever has a good attorney, they can drag the case out because they got more money to put on an attorney. They can drag the case on and on and on. Another party that don't have no money just gonna have to suck it up. I mean, it's hell to be poor. It is hell to be poor. If you're poor and you don't have a good representation, it can work bad for you. I've heard of people that went to prison for a crime they did not commit because they didn't have a good attorney. So again, it boils down to getting a good legal representation, in my opinion. Somebody say, okay. All right. I got a comment that I can't read the comment online, but okay, Jacko, stop asking how everybody is doing. We almost finished the program. You've been asking that all night. Thank you very much for being on our program tonight. Everybody is doing well, I think. If you have a question or comment related to what we are talking about, that's what I want to see in the comment right now. All right. Well, I think that is all the question we know will be. Somebody asking a question about wills and trusts and irrevocable trust and revocable trust. I think is beyond the scope of our topic tonight.
Yeah, that's wills and probates. Yeah.
Okay. You don't do that though, do you?
No, I don't do
No.
that.
Okay. So we will try to get another attorney to talk about that. If you have any other question tonight for Attorney Hopes, let us know. Now, somebody comment that now it boils down to what you can prove. And Oshole has said that many times. Yeah, but you can't prove it if you don't have a good attorney. And you can, what can you prove when you have a dummy attorney?
No, but actually, Pastor, sometimes clients don't even help their attorneys to help them prove their case because the attorneys don't reside with you, right? So it's what's the story you come to or whatever you narrate to them. And I feel like sometimes clients see their attorneys as judges, right? It's always good to be transparent to your attorney so that they can help you. But when you come to your attorney and you're trying to present your case in a manner, or would I say, you act like the attorney is the judge and you come with all sort of lies, it's not going to help your case in any way because the attorney doesn't really know what is going on. And it's only when they know what is going on that they can actually help you.
Yeah, but my experience has been when people have bad attorneys, they lose a case, a good case.
Yeah.
People have bad attorneys, they've been locked up in prison for life. And then come to find out 10 years later, they didn't have a legal representation. So talking about what you can prove, your attorney has to be able to prove it or disprove it. Again, I think it boils down to having a good legal representation. There are cases today where people have spent years in prison for a crime they didn't commit, or because the legal representation was not good. And the jury just went by what was presented to the court. They can read your mind. They can read your attorney's mind. And if your attorney is not that good, if you get a Walmart attorney, okay, you're going to get a Walmart judgment. That's the bottom line. I mean, you get an attorney and the good attorney is able to prove that you committed a crime that you never committed. But your attorney that's representing you is not able to prove that you were not there, you didn't commit the crime. And again, there have been cases where people go to prison for crimes they did not commit. People have spent 40, 30, 20 years in prison for a crime that they found out later with all the evidences, the thing that they use now with the science and all that, where they find out there's no way this guy could have committed this crime because he wasn't even there. They didn't find any blood. The police did some crazy stuff. The person didn't have a good legal representation, or they lost the case over technicalities and things like that. So again, it boils down to getting good legal representation. That is, I think, that's my take. I don't know what your take is, and you fool around and get sued and don't have a good attorney, you're going to end up in prison because there's so much, there's so many legal terms that you don't know. And if you have lawyers that are Walmart lawyers or Target lawyers, the one that you bought online, that don't really, they took a little of your money, you're going to end up in prison for something you did not do because you are not able to prove it, and your cheap attorney is not able to prove it. Your attorney is not the one going to prison, you are. So again, in my opinion, in your best interest, get a good legal representation if you want to win a case. Because good lawyers will know how to prove your case. Bad lawyers will do you a bum job. Just like you have good doctors. Good doctors will do surgeries, and then bad doctors will botch up your surgery. Both of them are doctors. So I guess, Attorney Oshole, I give you 30 seconds to close us out tonight. Closing comments.
Okay, so basically I just wanted to state that if you are going through a divorce, it's good to always get an attorney that understands your situation. And I would advise that you also be transparent with your attorney as much as you can. If you know that, or if your attorney asks you, have you ever, or have you been involved in the child's life, there's no need for you to lie. Tell them the truth so that they will know how to tackle these issues, and then they'll be well prepared for the case, because sometimes, surprises springs up and they don't know how to tackle it because you never disclosed that fact to them. So.
All right. Well, I think that's all we're going to end tonight. I want to thank Attorney Ushole hopes. I try to ask all the questions that you all are asking, okay? I try to ask all the questions and she gave us legal answers. Amen. So I want to thank Attorney Ushole Hopes for joining us tonight. Well, family, I love you all. I pray that your relationship goes smooth, that you stay in your marriage, and pray for God to bless your marriage and grow your marriage. I pray that the love of your life will treat you right, and that you will understand that marriage is a covenant and try to walk through the challenges. Don't get a divorce because they burn the rice. Don't get a divorce because they can't match colors. Or they call it irreconcilable differences. And people get a divorce for just foolish stuff. If there's a situation in a marriage, try to get counseling, get a godly counsel, and see if things can be worked out. But if you cannot, then I understand. You don't want to just get a divorce just because you feel like it. Or I mean, it's not the will of God. The will of God is that we stay in our marriage until death do us part. But I'm not going to advise you to stay in an abusive marriage. If your marriage is abusive, whether verbal abuse or physical abuse, yeah, I encourage you to separate from the party that's abusing, from the abuser. Separate from them, and then, put a restraining order on them. And if they cannot get help, then it may end up in a divorce. But it's always a good idea to try to find a way to reconcile. And if it's possible to reconcile. Well, I keep you all in prayer. I'm going to keep your marriage in prayer. I'm going to keep your relationship in prayer. We thank Attorney Ushole for giving us all the legal matters as it relates to family matters, marriage and divorce and child support and custody battles and all that. Until next Thursday on this same channel on our program, What's Going On? This is your host, Pastor Akin Bandele. Good night, family. God bless you. I love you.